I want to welcome you all here today for this lecture. My name is Bethany DeMin. I'm the Student Interns and Lectures Coordinator here at Family Research Council. It's my pleasure to welcome you here for today's timely lecture on religious liberty and same-sex marriage ceremonies. For those of you watching online, welcome. We're glad you're with us. Just a reminder to everyone that we do film and archive all of our lectures on our website. We find that our reach is greatly increased by shares on social media and online views. So please keep an eye on the website, and when you see the link becomes available, please feel free to share it. On behalf of FRC, I would like to extend a special welcome to today's speaker, Dr. Mark David Hall. Dr. Hall has been at George Fox University in Oregon since 2001. He received a BA in political science from Wheaton College and a PhD in political science from the University of Virginia. His primary research and writing interests are American political theory and the relationship between religion and politics. He has written or co-edited multiple books, the titles of which you can find on our website or on other places online like Amazon. Dr. Hall has also written more than 50 journal articles, book chapters, reviews, and sundry pieces. Most recently, he has edited Faith and the Founders of the American Republic and is co-authoring a book tentatively entitled America's Godless Constitution, Deist Founders, and Other Myths About Religion and the American Founding. He also serves as a senior fellow at Baylor University's Institute for the Studies of Religion. Would you join me in welcoming Dr. Hall?
Well, thank you very much, Bethany, for the kind introduction, and thank you, Rob, for having me here again. It's always a pleasure to be back here. So the legalization of same-sex marriage and the amending of states' public accommodation statutes have increasingly forced a number of Americans to choose between their livelihoods and their religious convictions. In just the last few years alone, there have been several high-profile cases where individual business owners have been threatened with ruinous fines because they refused to participate in a same-sex wedding ceremony. The recent Supreme Court decision legalizing same-sex marriage in all 50 states has the potential to make the number of cases of this nature increase exponentially. Last fall, the Alliance Defending Freedom asked me to be an expert witness in one of these cases. Let me just take a moment to introduce you to the defendant. Beryl Stutzman has been a florist in Richland, Washington for more than 35 years. For more than 9 years, and this is real important to make sure you catch this if you don't catch anything else, for more than 9 years, she knowingly and willingly served Rob Ingersoll and his same-sex partner. On multiple occasions, she created floral arrangements for birthdays and anniversaries and things of this nature. Now, in 2012, she heard through an employee that Mr. Ingersoll was going to ask her to provide flowers for his wedding ceremony. She talked it over with her husband and concluded, in her own words, that, quote, "My faith teaches me that marriage is between one man and one woman. Marriage is a sacred covenant between a man and a woman, as Christ is to the church. To create and design something from my heart that helps celebrate their marriage would be dishonoring to God and to my conscience." So when Mr. Ingersoll came into the store to talk with her, she gently told him that she would be unable to provide flowers for his ceremony, and she gave him a referral to a florist that had no such objections. Now, because of this, the state attorney general and the ACLU came down on her like a ton of bricks, and she faces ruinous fines that could absolutely drive her out of business. A judge ruled against her a few months ago, but the case is still being appealed. Now, this isn't a major part of my argument, but let me do make this qualification. I think it's important to note that this is not a mindless bigot. This is not someone who just hates homosexuals. She knowingly worked with this homosexual couple. She hired homosexuals. She regularly serves homosexuals. She just felt, as a matter of religious conviction, that she was unable to do this one particular thing, to participate in a same-sex wedding ceremony. I read through lots and lots of materials and depositions about this case. I haven't actually met her. I did have a chance to have lunch with the Kleins, the Oregon bakers, who are facing similar ruinous fines. And I asked them specifically, I said, look, what if two men came to you and said, we're two heterosexual men and we want to get married just for the tax advantages? Will you do our ceremony? And they said, of course not. It's not a matter of sexual orientation. It's a matter of how God designed marriage and whether or not we can, as business people, as Christians of good convictions, participate in these things. All right, so as you know, there are multiple cases going on throughout the nation of this nature. Bakers in Colorado and Oregon, a New Mexico photographer, a T-shirt maker in Kentucky. In my mind, these raise a number of interesting questions, important questions. What is the proper scope of religious liberty? How compelling is the state's interest in forcing business owners to participate in these sorts of ceremonies? Assuming that laws prohibiting discrimination on the basis of sexual orientation apply in these cases, would the state still be able to make its objective if the religious business owners were granted narrow exemptions from such laws? Should states adopt broad religious freedom restoration acts? And if so, what exactly should these acts cover? How should they be formulated? Now, oftentimes in answering these questions, people engage in hypothetical debates or public policy arguments disconnected from American history. What I want to suggest today is I think we can look at America's long history of accommodating religious actors who have objections to neutral, generally applicable laws, and that these cases, a wide range of cases, can shine important light on how we could approach this issue in such a way as to protect the rights of all Americans, or at least most Americans. Let me just mention my inclination. I've done a lot of work and I have a lot of examples. My inclination is to try to read these as quickly as I can so as to overwhelm you with evidence. I'm going to fight that inclination and try to speak very slowly. A much longer version of this argument will come out with the Heritage Foundation on its First Principles website in a couple of weeks, and I'll be happy to email a paper to anyone who would like, with a fully documented set of cases and a lot more examples and so forth. All right, so before I begin with the history, let me just ask, why accommodations? You hear this all the time. The law is the law and that's it, right? Well, why make an accommodation? Before I get into that, let me concede. Sometimes conservatives speak kind of loosely about how liberals don't like religious liberty. I think it's fair to recognize that almost everyone agrees, conservative, liberal, libertarian, socialist, that the government shouldn't be compelling people to engage in or not to engage in explicitly religious acts. In the words of James Madison, the government should not compel men to worship God in any manner contrary to their conscience. So if you look at the case law of the late 20th century, it's almost impossible to find an instance of the state saying you have to engage in this religious exercise or you can't engage in this religious exercise. In one of the rare instances where a town attempted to do this, Hillel, Florida, said, "Thou shalt not commit animal sacrifices." And of course what you had is a small group of Santeria that were engaged in this religious activity. So here is an example of the state, a city, prohibiting a specific religious activity. When the U.S. Supreme Court looked at this, the court said, "You have got to be kidding," and dismissed it 9-0. You can't tell people they can't engage in a particular religious exercise. So this really isn't a threat to religious liberty. The threat to religious liberty, particularly over the last 100 years, and particularly with the explosive growth of the national and state governments, have been general laws, neutral laws, laws that are not aimed at particular religious practices. And these laws are oftentimes, they're at least aimed at promoting the common good. So what do we do then when you have a law aimed at promoting the common good, and yet it prevents people from engaging in certain religious practices or practices motivated by their religious convictions? What should we do? Let me, by way of a case study, suggest what American colonies did with their friends the Quakers. The Quakers, often at odds with public culture. In early colonial America, of course, early colonies are in a precarious situation. They face a number of threats. In part, in order to help protect themselves, they required, generally speaking, every adult male, with a few exceptions, to participate in the militia, such that if there's an Indian attack, people can grab up their guns and fight off the attack. Now, our friends the Quakers, I think I have a nice little slide here, they object to this. The Quakers are pacifists. The Quakers says we can't use violence. We can't use lethal violence. This goes against our religious convictions. So what do? How are you going to protect religious liberty and protect the state? Well, one radical alternative is you could say, okay, let's remove this militia requirement altogether. Then the religious liberty of the Quakers will be protected. But of course, this imperils the common good. Now the colony might not be able to defend itself, so this isn't necessarily a good option. Another option, and this is an option that far too many states have taken, countries have taken, is to just say to heck with the religious convictions. Look, you Quakers, you serve in the military or you go to jail, or perhaps we'll even execute you. This is not an uncommon approach, not in America, but in other countries, including countries around the world today. At their best, however, Americans have opted for a third way, I think a very prudential way and the right way. In order to protect the common good and protect religious liberty, what states have done and what the early colonies tended to do is they tended to say this. They said, okay, look, we're going to leave the militia requirement in place, but if you pay a substitute, Mr. Quaker, we will allow you to not participate in the militia. We will accommodate your religious conviction in such a way that we can still protect the colony and protect the right of conscience. And we'll talk a little bit about how these things have developed. Historically in America, Democrats and Republicans alike have partnered to create lots and lots and lots of accommodations to protect religious Americans from generally applicable laws. By one count in the early 1990s, over 2,000 of these. And so what I'm going to suggest is these, if we look at these, I'm going to give you a number of examples I think can provide a guide, or at least some useful information to help us think about this particular case before us today. Let me stipulate just from the get-go, though, that of course not all religious practices can be accommodated. We're not going to allow, and we should not allow, Aztecs to sacrifice babies to the sun god or things of this nature. And that was not actually a case, but as an example given in Reynolds versus the United States. More realistically, in the 20th century, as we'll see, a number of religious groups, particularly the Christian Scientists, argued that parents shouldn't have to provide medical treatment for their children for religious reasons. A number of states initially adopted accommodations for these parents, but then when literally hundreds of children died from easily preventable diseases, states removed these accommodations, appropriately so. So it's obvious that not every act based on a religious conviction can be accommodated, but most can. So let me begin by returning to military service. And what I've done is I've tried to pick the hard cases, right? If there's any role for the national government, certainly national defense has got to be one of the number one things that the national government does to protect the country from external threat. And particularly, this might make less sense in today's highly technical military environment, but historically, if you want to successfully defend yourself, if you want to fight a war, you need troops, maybe even a lot of troops, particularly think of World War I, World War II. Literally millions of people need to be sent off to war. Historically, in America, the states were the main providers of manpower for America's conflicts through the 19th century. Generally, they provided this accommodation I mentioned already. You don't have to go if you're a pacifist if you hire a substitute. Once we get to the 20th century, though, the first major draft act of the 20th century, the Selective Service Act of 1917, specifically provides for an exemption for, quote, any well-recognized religious sect, organization at present organized and existing, whose creed or principles forbid its members to participate in war in any form. So what this act did in 1917 is it said, okay, look, if you're a member of a historic peace church, the Quakers, the Mennonites, the Brethrens, you don't have to fight and you don't have to pay anything. You don't have to hire a substitute. We are going to require non-combatant service of you. And if you don't do that, then you'll be put in jail. But otherwise, pretty well protected. Now, you might object, this isn't really fair to other religious pacifists. Probably we all know a Baptist or a Catholic who is also a pacifist. And that person would not have been protected under this 1917 Act. But by the time we get to 1940, what we see, the Selective Service Act of 1940 exempts all religious pacifists. And very appropriately so, I think. Again, still requiring the non-combatant service. Incidentally, in Arver versus the United States, in 1917 case, this accommodation was challenged as a violation of the Establishment Clause. Isn't this favoring one religious group over the other? And the court just simply dismissed that out of hand. Of course not. It's well within Congress's right to protect certain religious minorities if it sees fit. This is not a constitutional requirement. The U.S. Supreme Court has never held that the First Amendment requires an exemption from military service, but it's a legislative one. It's become a very rich legislative one. All right, let me press on. I skipped over this nice quote where the Continental Congress supports this. I will mention I skipped over this too. I'm going a little too fast. This is kind of fun as a matter of trivia. And what became the Second Amendment? Madison originally had this language: a well-regulated militia. You're familiar with this. But no person religiously scrupulous shall be compelled to bear arms. So the Second Amendment almost contained a religious accommodation for our pacifist friends. Roger Sherman supported this. Ultimately, the Senate rejected it, and it didn't make its way into the Second Amendment. But in the first Militia Act, Congress created such an exemption. And again, it's really the states that are involved in raising manpower through the 19th century, so this was less important. All right, let me jump forward, though, to oaths. Okay, and the oath of office, oath before a court. Historically, oaths have been seen as essential for ensuring the loyalty and fidelity of citizens and elected officials. They are also viewed as critically important for the functioning of an effective judicial system. Let me quote briefly from George Washington's farewell address, where he observes that of all the dispositions and habits which lead to political prosperity, religion and morality are indisputable supports. A volume could not trace all their connections with private and public felicity. Let it simply be asked, where is the security for property, for reputation, for life, if a sense of religious objection desert the oaths, which are the instruments in investigation in the courts of justice? So the state, it seems to me, has a real important interest, a high interest in the loyalty of its citizens in an effective judicial system. And oaths have historically been seen as critical for these things to work well. Now, of course, we return to our Quaker friends. Quakers don't take oaths. They believe that it violates a clear biblical command, such as James 15:12, but above all, my brethren, neither swear, neither by heaven nor earth, neither by any oath, but let your yea be yea and your nay be nay. So Quakers don't take oaths. They absolutely refuse to do so. Now, this got them into a lot of trouble. In England, they were routinely jailed for refusing to swear oaths in court, or after the Revolution of 1688 for not taking oaths to the new regime. Now, in 1690, and I come from a Friends tradition, I teach at a Friends school. I'm not sure I buy this distinction, but it's apparently very meaningful for many of my Quaker friends. The Quakers don't take oaths, but they're willing to take an affirmation. And beginning in the 1690s, Parliament said, okay, we're kind of tired of jailing these literally tens of thousands of Quakers, and so we'll let you take an affirmation. I solemnly affirm I'm telling the truth. And these sorts of accommodations then were made in America. Pennsylvania, founded by the Quaker William Penn, obviously had these sort of accommodations from the get-go, but other states fell into line pretty rapidly. New York, 1691, Maryland, 1702, New Jersey, 1722, Massachusetts, 1743. By the time you get to the American founding, each and every state allowed Quakers to give an affirmation instead of a oath. Now, one reason this is particularly important is because the U.S. Constitution itself contains a religious accommodation. There are 3 different oath provisions in the Constitution, in Article 1, Article 2, and Article 6. And each of these permits someone to, say from Article 2, the presidential oath of office, before he, the president, enter in on the execution of office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office, and so forth. So the U.S. Constitution itself clearly has an accommodation for religious minorities. Now, you might object, couldn't anyone do this? Couldn't anyone take the affirmation? Do you have to be religious to take it? And obviously the answer is no. Anyone could take the affirmation. But when we look at the context of the time when the Constitution was written, drafted, ratified, clearly this was an accommodation aimed at protecting Quakers and Moravian and Brethren and the relatively few small sects that refuse to take oaths. Okay, so, I began by telling you about how important these things are. Is there any serious argument to make that Quakers have been less loyal than non-Quakers, that they've been less trustworthy in the judiciary? And in fact, the answer is no, and almost opposite is true. Quakers became phenomenally successful merchants in the 18th century, in part because their word was their bond. You didn't have about a Quaker merchant taking advantage of you or not keeping his word. So again, the state has been able to accommodate this particular religious conviction without hurting significant interest on behalf of the state. All right, well, many of you probably think education is a good thing, all right? Certainly in America in the 19th century, as the public school movement got up and running, reformers thought this was critically important. We had these large waves of immigrants coming to America, and they needed to be educated and, more so, be made into good, democratic, and even Protestant citizens. And so states after state began adopting public school and, more importantly, requiring children to go to these schools. Now, these did tend to be biased towards Protestantism, as I've suggested, but it was pretty rare, actually, that states would require children to go to these Protestant schools. They were just sort of the default option. Now, these schools became significantly less religious. In the modern era, 1962, school prayer was removed, 1963, devotional Bible reading, and so forth across the board. So what do you do if you want a religious education for your child? Again, it's hard. It's real easy for you all to imagine, but back in this era, you need to understand homeschooling is almost non-existent, and oftentimes it's actually very difficult to get private schools up and running. All sorts of requirements of the state for certification and so forth. So what do you do if your conscience tells you need a religious education or education of a particular sort not provided from the public school, and you have these mandatory school attendance laws in place? Well, one group of that ran afoul of these sorts of requirements were the Amish. The Amish are good people. The Amish reject the modern world. They go around in buggies, as we all know. They reject buttons as being too flashy, wearing little hooks to keep their clothes together. They're pacifists. They avoid a lot of contact with the outside world. Now, these Amish in Wisconsin, New Glarus, Wisconsin, they actually did not object to sending their children to the local public schools, a local public school, through 8th grade. They believe in reading and writing. But they said, we simply cannot send our children to the public high school. They will be corrupted. They will lose their way. This is a direct affront to our religious convictions. The U.S. Supreme Court looked at this, and in this particular case said the First Amendment requires an exemption. You don't have to get rid of the mandatory attendance laws. Most kids in Wisconsin have to go to school through the age of 16, but this particular sect that has a profound religious conviction against sending their kids to school, they don't have to do so. Now, again, states have a tremendous interest in making sure the citizenry is well educated, but I don't think anyone would say that these sorts of accommodation or exceptions actually hurt this interest. And in fact, since this era, it's become a lot easier to homeschool and have private schools. And generally, homeschool kids, private school kids tend to outperform public school kids by most measures. And so it would seem these things don't hurt the state's interest in having a well-educated citizenry as well. This next one's going to sound sort of odd, because I already began by saying the state seldom requires explicitly religious acts. There are more instances where it did in the late 18th, early 19th century. I'm going to skip those to touch on a case that I find just fascinating and immediately appropriate to what we're talking about here. So as the United States was heading towards World War II, a number of states adopted statutes requiring children to salute the American flag and to pledge allegiance to the American flag. They said this is necessary as a matter of national unity, for national security. Everyone should be doing this, so we're all on the same page, right? Now, this generally is fine for most people. Probably most of us would have no problem doing it and maybe even think it's a laudable practice. However, you do have this tiny sect out there, the Jehovah's Witnesses. The Jehovah's Witnesses believe that saluting and pledging the American flag is equivalent to worshiping Baal. To them, it is a religious exercise, and one that the Bible tells them not to do, Exodus 24-5 and elsewhere. And so they refused to do this. They said, we will not do this. This case went to the U.S. Supreme Court in 1940, and the justices, by a vote of 8-1, said, too bad for you, little Jehovah's Witness kids. Our interest in national unity is so great as to overwhelm your religious objection. Well, that's interesting. Very seldom has the Supreme Court changed its mind so quickly. A similar, almost exact same fact pattern came to the U.S. Supreme Court just a couple years later, West Virginia versus Barnett, 1943. A couple of justices had retired. A couple changed their mind. And this time, by a vote of 6-3, the U.S. Supreme Court said, no, state, no, you cannot force these Jehovah's Witness kids to engage in what they consider to be this religious activity against their conscience. Justice Jackson famously wrote, the very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of public controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, to free press, freedom of worship and assembly, and other fundamental rights may not be submitted to the vote. They depend on the outcome of no election. So after considering the state's interest in national unity, Jackson went on to say, I don't have the quote, but I'll read it. I have the quote here. "If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. If there are any circumstances which permit an exception, they do not occur to us now." Let me emphasize something that I think is tremendously important about this case. I'm going to guess most of us are not Jehovah's Witnesses, and we do not agree with the Jehovah's Witnesses on this point. Even though we would all say our ultimate allegiance is to God, at least I certainly see myself as being able to pledge allegiance to the American flag, and that not being incompatible with my ultimate allegiance to God. So I think the Jehovah's Witnesses are wrong on this point. I have also, as I've been involved in this, I've met a number of people, a number of good Christians, who think Barronelle Stutzman is wrong. They say, if I was a baker, I would bake a cake for a same-sex wedding. All right? And I say more power to them. The question in this case is not about what the majority thinks, it's about what the Jehovah's Witnesses think. The question with respect to the baker is not what you and I think, would we bake that cake or not, but can we recognize that Barronelle Stutzman has a religious conviction against doing this, and should we protect that or not? That's a question. Do we really want judges only protecting religious liberty claims that are right or true or held by the majority? I would think not. Well, let me jump to another category here, alcohol and drugs. I think we all know that untold devastation has been caused by alcohol and drugs in our culture. In the 19th century, a powerful movement arose to ban alcohol altogether because it was seen as leading to so many evils. Of course, a few states got on the bandwagon, and eventually the U.S. Constitution was amended to ban alcohol throughout the nation. When Congress wrote an act, the Volstead Act, to implement this, Congress very rightfully, I think, recognized that there need to be exceptions to this general ban on alcohol, and a specific exemption was created for sacramental use of wine. Now, many of us might be Protestants, and we might say, what's a big deal? We use grape juice. We don't even need wine, right? And that's fine, and that's how I grew up, and no problem with that. But, of course, a lot of traditions insist that it really needs to be wine. You can't substitute grape juice or other things for the wine. And so these were accommodated. You might think these accommodations have been eliminated altogether now that prohibition has been overturned, but I was going through Oregon statutes the other day and ran across one that was kind of interesting. Basically, it says adults can't serve alcohol to minors unless A, you're the parent of the minor, or B, you're a minister or clergy or rabbi, right? And because you do have these scenarios in churches where you use wine, where the minister would in fact be giving wine to a minor, and this is specifically protected even to this day. So we have these accommodations for the sacramental use of wine. Now, most of us can say, well, that's kind of an easy case. What's the big deal? Drugs, however, that's a different category altogether. A lot of Americans still believe, people argue about this, people want to legalize drugs, or at least certain drugs, but a lot of us still believe narcotics are bad. They ought to be illegal. They cause far too much harm. But what do you do then in the case where you have Native Americans who say, we need to use peyote in our religious ceremonies? And these ceremonies have clearly been documented. It's going back hundreds of years. It's not just some little flippant way to be able to use drugs. Well, Congress recognized that these Native Americans could be, peyote's illegal. It's clearly illegal. Congress in 1966 said we ought to make an exception specifically for members of the Native American church, not Native Americans in general, not religious Americans who want to use peyote in general, but for the specific church, we will make an exemption. A number of states adopted similar accommodations, but not the great state of Oregon, my home state. And so you had a famous case coming in 1990 that involved unemployment compensation. But basically it came down to, can the state ban this? And the U.S. Supreme Court said yes. Yes, the state can ban this. Native Americans in Oregon, out of luck. You don't get to participate in these religious ceremonies. Well, fortunately, from my perspective, Oregon saw the light and almost immediately amended its statutes to specifically protect the ability of Americans to use peyote in religious ceremonies. Congress, partly in response to this, partly in response to broader issues, passed the Religious Freedom Restoration Act. And one thing I want to emphasize here is sometimes it might seem, if you've been following the news over the last year, that religious liberty is a Republican issue. It's not historically anyway. The Religious Freedom Restoration Act passed to protect people like Mr. Smith in this case, and religious liberty in general, was passed overwhelmingly. I think, let's have the vote, 93-3 in the Senate, unanimously in the House, and it was signed into law by President Bill Clinton. Historically, Democrats have been just as likely to protect religious liberty as have Republicans. So, and incidentally, I should mention as well, after this, the Congress amended the American Indian Religious Freedom Act to try to force or require the other states to create similar accommodations. All right, so we can all agree, I think, that at least when they're abused, drugs and alcohol have led to a lot of problems in this nation. But I don't think you make a plausible argument that these religious exemptions contribute to this in any significant way. All right, two other major categories. Medical treatment. All right, so traditionally, the state and the national government has stayed out of the business of what medicine you take when, right? These sorts of decisions should be left up to individuals. However, as medical science advanced, it became evident that things like vaccinations, decisions you make with vaccinations can affect others. And if too many people aren't vaccinated, this could lead to the continued existence of a disease. And so a number of states passed laws mandating that everyone has to be vaccinated. The U.S. Supreme Court considered these laws in 1905 and said that the state's profound interest in public health outweighs any liberty interest you might have in objecting to these vaccinations. And so today, 50 states require vaccinations before you go to school, public or private. What's interesting, though, is 47 of them specifically exempt parents who have religious objections to these vaccinations. Every state, in fact, except Mississippi and West Virginia, and as a few weeks ago, California. California recently revised its statutes to remove this religious exemption. Many states as well, about 17 now, 18, have exemptions for philosophical concerns. And every state has one for medical. If you have a good medical reason to not get vaccinated, you don't have to get vaccinated. All right, so the health and safety of citizens, it's obviously a vital state interest, and yet even in this policy area with respect to vaccinations, states have been willing to craft accommodations aimed at religious believers. And yet I think it's very appropriate. If you recall, the California revised its statutes because you had some outbreaks of measles, in part because too many people in particular weren't being vaccinated. I think it's eminently appropriate to look at the harms that might come from a religious exemption. So don't think I'm arguing that any act motivated by religion has to be let off scot-free. It's very reasonable for policymakers to look at this and say, okay, should we continue this exemption? Should we amend it? In this case, I would say West Virginia, Mississippi, and California go too far. I think you should remove the philosophical exemption, narrow down the religious exemption, make it hard to get, but you could still protect religious Americans who have these sorts of objections, who aren't that many people, by the way, and promote the public health. Let me say again, it's at the risk of being repetitive, but in the early 20th century, Christian scientists lobbied for widespread exemptions with respect to the health of their children. When many children died, states properly removed this sort of exemption, a clear instance of where religious view, an action based on a religious view, shouldn't be accommodated. All right, my last category then is medical providers, those who provide medical treatment. Perhaps the most difficult moral issue, at least as a broad culture, that we've dealt with over the last half century concerns abortion. This is, it's very difficult, right? A lot of Americans consider abortion to be tantamount to murder, whereas others say it involves a fundamental constitutional right. So this raises the issue. This is not a general debate about abortion or not, should it be legal or not, but the question of if you're a medical provider, a doctor, a nurse, a pharmacist, should you be required to perform an abortion, to dispense a pill that may be an abortifacient, to participate in a sterilization? These sorts of issues are raised by this. And you could imagine there could be a hodgepodge of responses, state by state, hospital by hospital. Generally, I'm not one prone to look for national solutions, but there was one that was developed in 1973, which I kind of like. Shortly after Roe versus Wade, Congress passed a church amendment to protect healthcare professionals. Now, this legislation specifically prohibits any court or public official from using the receipts of federal aid to require a person or institutions to perform an abortion or a sterilization contrary to, quote, their religious beliefs or moral convictions. The amendment states it's illegal for healthcare organizations to discriminate against individuals who refuse to perform these procedures. In arguing in favor of these protections, Senator Frank Church, a Democrat from Idaho, argued, I think I have this here, nothing is more fundamental to our national birthright than freedom of religion. Religious belief must remain above the reach of secular authority. It is the duty of Congress to fashion a law in such a manner that no federal funding of hospitals, medical research, or Medicare may be conditioned upon violations of religious precepts. So in other words, you can't use the receipt of federal funds as a wedge to require people to do this sort of thing. But Congress went further. In the 1990s, it passed the Danforth Amendment, in 1996 technically, which prohibits the federal, state, and local governments from discriminating against healthcare entities that refuse to A, undergo abortion training, B, provide such training, C, perform abortions, or D, provide referrals for training or abortion. So under this law, a hospital could say, look, we aren't going to do abortions, we aren't going to teach people how to do abortions, and if someone comes to us wanting an abortion, we don't even have to refer to them to a place that gives abortions. Okay, a pretty widespread protection of conscience in this area. Now, like Congress, a number of states have gotten into this act. According to, I don't usually go to this as a source, but according to NARAL, the National Abortion Rights Action League, 47 states in the District of Columbia have passed laws that permit certain medical personnel, health facilities, institutions that refuse to provide abortion care. Only Alabama, New Hampshire, and Vermont do not have such laws. It's noteworthy that many, but not all states specify that these are to protect people who have religious or moral objections. I am glad it includes moral, but for my purposes, I want to emphasize that what states are doing, what the national government is doing, is it specifically protecting the consciences of people who are making decisions based upon religion. All right, let me say this. Well, I've read a lot of the law review literature. A lot of people hate these sort of exemptions and accommodations for medical professionals. There's a lot of hypothetical worry about what might happen. You can pretty easily spin up all sorts of cases where people are denied treatment and whatnot. What is striking is there's so few real-life examples where this happens. Again, though, I would say this is one of those areas where it might turn out that some of these exceptions, some of these accommodations are too broad. They might need to be narrowed in certain respect. But this should be an evidence-based argument, not a law school argument based on kind of crazy hypotheticals. All right, so over the last 20, 25 minutes, what I've given you is a number of examples where American states and the national government have gone out of their way to protect religious actors. These are areas of key national importance or state importance: national defense, oaths, national unity, education, drug use, healthcare, and so forth. Again, I would point you towards my longer essay that will be available in a few weeks at the Heritage Foundation's First Principles series with full documented footnotes and this sort of thing. Let me suggest a few lessons, though. Okay, it seems to me that this value Americans have placed on religious liberty for a long time, Democrat and Republican, going well back in the 19th century, particularly into the 20th century, should inform these debates. I think far too often the religious convictions are just dismissed too readily in these things. Religious liberty is an important interest. The state should go out of its way to protect it. Now, this interest does have to be balanced against other interests. In looking at this, it's not unreasonable, it seemed to me, for the states to say we have an interest in prohibiting discrimination on the basis of sexual orientation. Indeed, about half of the states have amended their public accommodation statutes to prohibit this. It is interesting, though, if you go and look at these statutes, even these states, and these are the bluest of the blue states, they almost inevitably exempt clergy and religious organizations from these requirements. So even these deepest of blue states recognize that the state cannot tell a minister of the gospel that he has to marry two men, or that the First Church of the Nazarene has to host a same-sex wedding. So clergy and religious organizations and churches are actually pretty well protected, even under this legislation, the deepest blue states. In a few instances, very small businesses are given some sort of protection as well. But the people who are left out, of course, are the Stutzman and Kleins, business owners that believe that their faith should inform everything they do, including how they run their business. And so the question is, how do you protect a Baronelle Stutzman who is attempting to run her business according to her Christian convictions, when you have a general neutrally applicable statute prohibiting discrimination on the basis of sexual orientation? I've already suggested, I'm not sure it really was discrimination on the basis of sexual orientation, but that certainly is how the judge understood it to be. Well, there's a couple of different options. One option, kind of popular, particularly among many people in this crowd probably, and myself, would be to pass state religious freedom restoration acts. These offer a pretty broad and deep protection to religious liberty. It says, look, if you have a neutral, generally applicable statute, and this provides a substantial burden to a religious conviction, that statute can only apply to the person with this conviction if you have a compelling state interest and if this interest is met in the least intrusive means possible. Now, one would think that would give pretty good protection to people like Baronelle Stutzman. Unfortunately, in reality, they tend not to. I've seen some scholarship that looks at how these things play out on the state level, and generally these folks lose. Washington State requires this level of analysis as a matter of state constitutional law, and they just threw out Stutzman's religious liberty claim, saying the state clearly has a compelling state interest in prohibiting this sort of thing, and this is the least intrusive way possible. And as well, I look at something like the debate in Indiana where there was this profound overreaction. And again, you get into these hypothetical stories, which as a professor I can kind of like. They're useful pedagogically. And yet I think in the real world in which we live, they don't really reflect reality. So in Washington, for instance, when the state of Washington was debating a Religious Freedom Restoration Act, a reporter came up with the great hypothetical. What if you have a rural grocery store owner, the only grocery store for hundreds of miles around, and he refuses to sell food to homosexuals? What would happen then? Well, I'd say, to begin with, I'm not sure. I've known a lot of religious people. I've never known anyone with that sort of belief, right, that says I can't sell food to homosexuals. And it's such a far-flung sort of example. Now, these things, I'm not saying it's illegitimate to use these sort of questions, particularly in a classroom. But if we turn to the world in which we live. So, for instance, Josh Freeds, a spokesman for the gay advocacy right, Equal Rights Washington, observed that there had been literally thousands of same-sex marriage ceremonies in the state of Washington, and the Stutzman case was one of the very few negative cases that we've heard. I think in weighing the state interest, we just have to say, how often does this sort of thing occur? It seems to be very, very little, very rare instances. And this one, it surprised those of us who recognize that businesses have profound incentives to serve customers, not turn them away. As well, in our level of analysis, I think we have to say, what are we talking about here? Are we talking about the ability to buy basic goods and services, food, plumbing, electrical work? We're talking about a wedding ceremony, right? So what's the harm if Baronelle Stutzman won't do the flowers for a particular wedding ceremony? Well, you might not get your ideal vendor. There might be a slight inconvenience, although in Richland, Washington, there's still dozens of florists within miles, so pretty easy to drive 5 minutes down the street and find another one. There is, and I think this is important to recognize, there might be a harm to dignity. It might be hurtful to be turned away like this, and I think we should take that into account in our analysis. It still seems to me, though, that given the relatively few instances in which we've seen this occur, we might say that a carefully crafted statute to protect the religious convictions of those that have particular objections to participating in same-sex wedding ceremonies could do precious little harm and could protect the sacred right of conscience. Now, you might say, if you're thinking about it, you might say, wait a minute, Hall, the 22 or so states with public accommodation statutes banning discrimination on the basis of sexual orientation, these are the most bluest of blue states. What about the red states? What about Oklahoma? What about Arkansas? In those states, you might very well have more wedding vendors that wouldn't want to do this sort of thing. But I would actually flip this argument on its head. So right now, these laws are being passed at a state-by-state level. Right? One of the chief objections in these red states are if we pass this sort of law prohibiting discrimination on the basis of sexual orientation, then we're going to see more cases like the Stutzman case and Klein case. We're going to see more business owners that are being faced with ruinous fines, $150,000, $130,000 for acting on their religious conviction. So we don't want those sort of a public accommodation statutes. However, if you had carefully crafted accommodations for these religious business owners, that might make it more likely for these states to adopt such legislation. Utah gave a perfect example of how these two sides might come together and come up with a compromise that not everyone likes, right? Both sides don't like it, but that's probably a good sign that it actually is good compromise. All right, so by way of coming to a conclusion, I want to remind you, and again, I haven't given you as much evidence as I could, but literally the state's codes are riddled with these religious accommodations, vaccination requirements, ritualistic slaughter, peyote use, on and on and on I could go, the use of feathers by Native Americans, all sorts of accommodations all over the place. And it seems to be the best way to address this problem is for states to craft careful, narrow accommodations that wouldn't allow a hamburger owner not to serve hamburgers to homosexuals in Indianapolis or that sort of thing, right? So we're not trying to provide a general license to discriminate. And I think very few business owners would want that sort of license in any case. But to protect the relatively few people that have a religious conviction against participating in a same-sex wedding ceremony, a ceremony, incidentally, many would view as an inherently religious ceremony. And so if religious liberty means anything, it sure seems that someone shouldn't be compelled to engage in a religious ceremony that one has an objection to. So with that, I will stop, and I would love to hear what you all think. Questions? Objections? Yes, sir.
Did I hear you right to say that right now, presently, like pastors and churches are protected from denying a same-sex couple to do their wedding, or are they open and vulnerable? I'm from California, so I know some of the leading pastors in our area, like Pastor Jack Hibbs, which I know works here with FRC, has said, I'm not going to do weddings at all, which I don't necessarily think is probably the best route, but maybe the safest at this time.
Sure, and my attorney friends tell me I should qualify everything I say, but I'm not an attorney. I'm not competent to give legal advice for the state of California or elsewhere. It's my understanding that in the states that adopted same-sex marriage and amended their public accommodations to and/or amended their public accommodation statutes through the democratic process, that all of these states have specifically exempted clergy, churches, and religious organizations. So I need to check California to know for sure. Well, we've run into a little bit of problem as you know, only 11 states have adopted same-sex marriage through the democratic process prior to the U.S. Supreme Court decision a few weeks ago. In other states, though, federal or state courts required it as a matter of constitutional law. So there you didn't have the legislation in place. So in Idaho, for instance, a kind of quasi-religious business, the Hitching Post, ran afoul of this when the quote-unquote minister there refused to marry two men, although even that case was resolved in the favor of the minister. So yes, it's my understanding that clergy, churches, religious organizations are very well protected where you have these things adopted through the democratic process. Congress, of course, is considering right now a similar law that would make these national. Good question. Yes, sir.
Even if states do pass these carefully crafted laws, like you see, even if states do pass these carefully crafted laws or accommodations, like you suggest, what's to stop possible pushback, like we saw in Indiana?
Yeah, that's a great question. Of course, part of that pushback is part of the democratic process, right? Corporations that say, if you have this policy, we will not do business in your state. I think they have every right to do that sort of thing. I guess my remedy for this, and this is maybe grand thinking, but I think Christians and conservatives need to engage in this sort of pushback as well. Perhaps to say to Apple Corporation, look, if you're going to support this side of the debate, you need to support our side of the debate, or we're going to boycott you, right? We aren't going to tell you what you have to do, but we want some sort of fairness here. And if they don't, then follow through on that. Yeah, I think there's probably a lot more sensible people in this country than there are leftist activist. And so if we would get together and do some pushback on our own, we could at least neutralize some of this corporate pushback that we saw in Indiana, but also in Arkansas. Yes?
We're here from Indiana, and we're seeing a collision with the First Amendment religious freedom with the protected gender identity groups getting a civil rights protection, and those two becoming opposed to each other, and that's where our concern is. So what remarks would you say about that? Because I think we're about to lose our religious freedom.
Yeah, no, this is exactly, Ryan, this is exactly my concern, that you have the states determining that they have an interest, although Indiana hasn't done this yet, right? Indiana as a state doesn't have a public accommodation statute prohibiting discrimination on the basis of sexual orientation. I believe some cities, perhaps Indianapolis, does. And so, yeah, there's where you're having business owners that run afoul of these statutes. So, yeah, what Indiana needs to, well, Indiana was trying to do it, and there's a big kerfluffle, is to pass legislation. Now, here's where Indiana might have gotten into trouble. Indiana went for the sort of big fix, a state RFRA, and that led to all sorts of speculation, right? You heard it, hamburger stores that won't serve athletes who are visiting our fair city and so forth. And I don't even think RFRA would have protected that action. But if Indiana had passed a more narrow, carefully crafted accommodation that might have been less controversial, and it might have passed more easily. Again, the problem with that is the democratic process take time. We have 50 states, and if you try to do this in each 50 states, that's going to take a lot of time. I like RFRA, but again, it's going to be a hard sell, particularly after Indiana. It was hard enough in Arkansas, right, a deeply red state. Yes?
Is there carefully crafted language somewhere?
Yes, there's a very good group of scholars, far more prominent than me, Douglas Laycock down at the University of Virginia, and others, Thomas Berg, Robin Whitehall, who've crafted model statutes. I like them. I maybe quibble with some elements of them. I think, generally it doesn't take a rocket scientist to craft these sorts of things. A statute that simply said that people shall not be compelled to participate in wedding ceremonies to which they have religious objections, maybe with some limitations on size. And you can always say there might be those rare instances that only florist within 300 miles of a particular location, where you might say the state has a compelling interest in requiring that florists participate in a same-sex wedding ceremony. Sometimes they suggest things like size. It's one thing to protect a small business owner. It's another thing maybe to protect Walmart that has this huge national scope. But yeah, so there is language out there, and I would point you towards that. And I can point you towards that if you contact me. But again, I think most legislatures should be capable of crafting this. They do it all the time. Our codes are just riddled with these sorts of accommodations. All right. I suppose I would close just by mentioning, I think it's tempting, particularly for conservatives, to feel, oh my goodness, we're being beaten up left and right. Religious liberty is very well protected in America today, even today. I know there are those that are pushing agendas that would cut into it significantly, but clergy, the ability to worship God according to dictates of our conscience, to evangelize aggressively, these things are very well protected as a matter of constitutional law, as a matter of almost all state law. The greatest threat really are these general, neutrally applicable statutes involving discrimination, involving hate speech as well. That's another one we haven't gotten into. And so I would just encourage all of us to be vigilant. Even if we say the state has an interest in prohibiting hate speech, and I find that problematic for a number of reasons, but even so, we need to be vigilant to make sure that accommodations are crafted for those sorts of statutes, and certainly for these public accommodation statutes that prohibit discrimination on the basis of sexual orientation. So with that, I will close. Thank you all very much.